Good afternoon and welcome to our 2020 Year in Review. We're so pleased that so many of you could join us this afternoon, and it's great to see so many familiar names in the attendee list popping up on my screen. This has been a big year for all of us and has brought with it huge changes to how we live and work, including to our Year in Review presentation, which for the first time is being brought to you live and online. This event is my favourite event that we present throughout the year, and it's always a lot of fun, and we hope that it's going to be helpful for you. The whole Canberra team will present today, and you'll be hearing from each person on a different topic, which is a slightly different format from our usual panel discussion that we have in these presentations. Given the online format, in lieu of questions this year, we've prepared some polls to go along with each section. If you're on a computer, those polls should pop up on the right-hand side of your screen. If you're on a mobile device, they should pop up under a text bubble in the top left corner of the screen. There's also a chat function which we encourage you to use throughout the presentation, although obviously please keep your comments professional and polite. In addition, there's a Q&A function, and you're very welcome to enter any questions you have as we go through the presentation. As you know, the purpose of this presentation is to look back on the year that has been and think about what we can learn from the cases and whether there are any trends that are emerging that we think you should be aware of. There is one trend that I would like to make some comment on, but before I do that, I feel it would be remiss in a Canberra FY20 Year in Review to not acknowledge the tragic passing of Deputy President John Kovacek of the Fair Work Commission last Friday. He was Canberra's primary sitting Fair Work Commission member for the last 7 years, taking over the position from Barbara Deegan in 2013, and I'm sure that many of us have worked with him or appeared in front of him. I'd like to dedicate this afternoon's presentation to DP Kovacek and his relentless pursuit of knowledge, and the enormous contribution he made to the IR community nationally and in Canberra. Our thoughts and prayers are with his family, friends and colleagues. Turning then to our first trend for the presentation. This first trend comes from a recent decision of the full federal court, Hughes and Hill. The case is not in the booklet that we have sent out to you, as it was handed down after our publication date, very recently on the 24th of July. But we will ensure that a link is circulated after the event so you have a copy. It involved an appeal to the full federal court of a decision to award $170,000 in damages, including aggravated damages, to a paralegal, a Ms. Hill, who had been subjected to sustained sexual harassment from her employer, Mr. Hughes, who was the firm's principal solicitor. The court rejected Mr. Hughes's argument that the damages awarded were excessive and upheld the original award of $170,000. Significantly, the court confirmed that the damages awarded in sexual harassment cases that were determined prior to the case of Richardson and Oracle in 2014, which were typically smaller in nature, were no longer good law. We discussed the Oracle case in our 2015 Year in Review. Hill and Hughes is likely to be relied upon in future cases as a trend in settlement negotiations and in decisions, raising the bar and the amount of damages awarded in sexual harassment cases. This is a critical reminder that courts will not tolerate sexual harassment in the workplace and are willing to come down hard on those engaging in this sort of behaviour. But what we love best about our Year in Review cases are their outrageous facts, and this one does not disappoint. In this case, Mr. Hughes submitted that the evidence before the court did not support the conclusion that he had sexually harassed Ms. Hill because, and this was his actual submission to the court, his behaviour was not harassing, it was more like that of Mr. Darcy in Pride and Prejudice. I'm not quite sure how compelling that argument is in circumstances where my view is that Mr. Darcy was a bit grumpy and aloof, and that would certainly contribute to a feeling of harassment. He further argued that his conduct was of the misguided but lofty-minded and romantic nature, therefore could not be harassing. The court, unsurprisingly, disagreed with those submissions, finding that Mr. Hughes's conduct, which included, and this is a quote from the judgment, ghost-like practices of hovering in doorways until dispelled by a hug, remaining in his female employee's bedroom dressed only in his underwear, frequently emailing his employee in poor French and with other declarations of love, and referring to himself as the sleek kangaroo and a wild and passionate man, clearly amounted to unwanted and repeated sexual harassment of Ms. Hill. This is quite simply one of the best judgments that I have ever read. Justice Perrin wrote the majority judgment, and it is just scathing of Mr. Hughes's conduct. I certainly encourage you to read it when we pass that link around after the presentation. All right, so let's turn now to the material in the booklet, which is set out on our next slide. This slide shows the different topics in the booklet and what we're going to talk about this afternoon. Unlike previous years, where you would have received a hard copy of the booklet on your way in, this year's booklet has been sent through to you as a soft copy along with your confirmation email. It's a terrific resource and makes great reading for a rainy Sunday afternoon. So I encourage you all to set aside some time this weekend. The weather forecast is looking particularly rainy, and read it cover to cover to get the full year in review experience. But that's enough from me. Without further ado, I'm now going to hand over to Belinda Miller, who'll kick off with our first topic, taking us through some of the key changes and highlights in the wild world of industrial relations.
Thanks, Jen. It certainly has been a very big year in industrial relations, and I'm looking forward to running you through some of those key highlights today. Understandably, many of the key developments that have occurred in industrial relations for the past 12 months have been in response to COVID-19. Before I go into these matters in detail, I want to emphasise that the key takeaway for industrial relations this year is that the changes which have been made in response to COVID-19 create permanent legal precedent. So while it's easy to think that these reactive decisions are limited to these highly reactive times, in reality, COVID has shaped an industrial landscape going to stay with us well beyond COVID. The first major IR event that I want to discuss is industrial relations reform. In previous years, we've always foreshadowed that IR reform might be coming, except last year where we speculated that systemic IR reform was not high on the current government's agenda beyond addressing public scandals like wage theft. However, this year, not only do we expect IR reform to happen, but we have a time frame for it. As you may have seen in the media, the government has convened 5 industrial relations roundtables as their way to achieve systemic IR reform and capitalise off the current levels of cooperation between unions and employer representatives. Each IR roundtable has equal numbers of representation from employee representatives and employer representatives, and they're designed to tackle the traditionally difficult issues such as casuals, award simplification, enterprise agreement making, compliance and enforcement, and greenfields agreements. These are all topics that many employers will be aware are viewed as roadblocking economic development and workplace flexibility, and are very high on the agenda for resolution. It remains to be seen whether the IR roundtables turn out the sort of outcomes that are predicted. While we have seen unprecedented levels of union and employer body cooperation in response to COVID, these issues are highly complicated and have been contentious between the parties for years. So whether this current goodwill can actually be turned into something longer lasting remains to be seen. However, Christian Porter, the Industrial Relations Minister, is very confident and has said that we can expect to see reforms as a result of these IR roundtables introduced on the 1st of February 2021. So watch this space. A next ongoing industrial relations issue which has caused headaches for many people for quite some time now is wage theft. The last financial year, like the years before that, has seen some pretty large-scale announcements of wage theft, including Qantas and ABC. While previously wage theft was very much on the federal government's agenda, over the past 12 months we've seen that slip off their agenda, I think due to the reaction to COVID-19. However, it remains very high on state agendas, particularly Victoria. Victoria, somewhat controversially, has introduced their own wage theft legislation. It has very serious punishments of up to $1 million in fines or 10 years imprisonment for employers found to have dishonestly withheld wages. However, this scheme has been very highly criticised by the federal government, who have said that this is a federal area of law to regulate and have not ruled out a constitutional challenge. The Victorian legislation is set to come into effect on the 1st of July 2021, so unless a constitutional challenge does occur before then, It's a good reminder for employers in Victoria to triple check compliance with any industrial instruments. The next IR area to watch is enterprise bargaining. I have two cases that I wanted to briefly discuss with you today. In previous years, we've spoken about amendments to the Fair Work Act designed to relax some of the very strict administrative and procedural requirements around making enterprise agreements. The first case aligns with this trend towards agreement approvals, looking at the particular circumstances of the parties instead of a one-size-fits-all approach. The first case on the slide there is CFMMEU versus C&H Acquisitions, and it relates to an enterprise agreement that C&H, a labour hire company, were seeking to introduce for their workers. The agreement, which was voted on and approved by the workers, did not cover high income earners on the basis that C&H didn't engage any high income workers. However, the approval proceedings before the Fair Work Commission, the CFMEU argued that there was nothing to prevent C&H engaging high income earners, and therefore they should be included in the scope of the agreement. In response, C&H gave an undertaking that the high income earners, if any were ever employed, would fall under the EA. The CFMEU then appealed that undertaking on the grounds that adding a new category of workers into the scope of the enterprise agreement was a substantial amendment to the EA, and therefore it could not be made by way of undertaking. On appeal, the Fair Work Commission full bench held that while the scope of an enterprise agreement is a fundamental feature of an EA, it was not a substantial feature in this case because C&H did not engage any high income earners and had not employed any during the life of the previous agreement. The case is interesting because it shows that while there'd previously been a trend from the Fair Work Commission to restricting the use of undertakings and what sort of matters an undertaking could be used to remedy, they're now saying that the undertakings are only limited if they are not going to be transformative. It also shows that the Fair Work Commission is more willing to consider the circumstances of a particular workplace when approving an enterprise agreement. However, we don't recommend relying on undertakings. It's still very important to check your enterprise agreement extremely closely before putting it to an employee vote. The second case that I wanted to talk about deals with good faith bargaining requirements, and in particular, how COVID cannot be used as the dog ate my homework excuse to get out of enterprise bargaining obligations. This case, the United Workers Union matter, dealt with Davies Bakery, which is a family-run business with approximately 240 employees. Davies Bakery were very reluctant to participate in bargaining to the point where the UWU had sought a majority support determination order against them in 2019, which forced them to bargain. In compliance with that majority support determination, Davies Bakery held one bargaining meeting. The second bargaining meeting, which was scheduled for late March, they cancelled, as this was just when COVID restrictions were coming into place. Davies Bakery then refused to schedule any further meetings. The UWU brought this matter to the Fair Work Commission, saying that this was a breach of the good faith bargaining requirements. Davies Bakery responded by saying that they were too busy having to deal with the impacts of COVID and could not be expected to bargain under these circumstances. The Fair Work Commission found in favour of the UWU. They said that COVID was not an excuse. They accepted that the first meeting, which was just as the COVID restrictions were coming into effect, it might have been reasonable to have cancelled that, as that was a very peak time. But they said more generally, COVID is not an excuse to not continue to engage with your industrial obligations. And in fact, it could be an opportunity for Davies Bakery to have liaised with their employees and come up with some mutually agreeable ways to manage the impacts of COVID-19. The key takeaway from this case is that COVID cannot be used as an excuse to avoid any industrial obligations. While it might be tempting and in fact necessary to focus almost all of your energy on COVID-19 responses, just as legal precedent is marching on and will continue to affect us when COVID scales down, industrial issues and obligations will continue to exist and will still need to be dealt with. We've also seen lots of enterprise agreement variations coming out in response to COVID-19 to help businesses survive, for example, by freezing scheduled pay increases. So industrial negotiations might actually be beneficial to employers at the moment. Unlike enterprise agreements, modern awards have not been business as usual under COVID. While awards are often criticised as being overly complicated and inflexible, we've actually seen some really unprecedented flexibility in awards to counter the effect of COVID-19. This has mostly come about through this unprecedented cooperation between union and employer parties, which I mentioned earlier, where they're actually cooperating and putting joint applications to vary awards. Some big changes that we've seen are the introduction of paid and unpaid pandemic leave, broader powers for an employer to change an employee's hours of work, and provisions around accessing leave at half pay. My wonderful colleague Caroline is going to talk a little bit more about flexibility later. Another big award change this year was our annual wage review decision. For the first time ever, we saw a split decision, and we also saw staggered wage increases. So while the Commission did decide to order a 1.75% wage increase, instead of making that come into effect for all award-covered employees from the 1st of July, they've staggered it across industries depending on how severely an industry has been affected by COVID. Industries which have not been severely affected, the frontline industries such as health and education, will receive their pay increase from the 1st of July, whereas very seriously affected industries such as retail, tourism and hospitality won't receive their pay increase until the 1st of February 2021. Moderately affected industries will get theirs from the 1st of November 2020. Briefly on the APS, we have seen some major changes in APS industrial relations as well, and we expect more to come about as the outcome of the 30 review begins to be actioned. The first major change is a significant demise in enterprise bargaining. As our public service friends are aware, the APSC workplace bargaining policy has created restrictions on what can be bargained for. In response, more and more agencies are turning to the Public Service Act, which includes the ability for an agency head to issue a determination setting terms and conditions for employees of that agency. Under APSC policy, the employees still need to be in favour of this determination. However, instead of needing to bargain with union representatives, many agencies have instead asked staff to vote on short determinations, which maintain the terms and conditions of an existing enterprise agreement, but provide the maximum 2% pay increase allowed under APSC policy. These have proven to be extremely popular. So in the 2019 calendar year, we saw 14 agencies vote in favour of enterprise agreements compared to 41 agencies voting in favour of agency head determinations under the Public Service Act. This might be a sign of things to come for the future and is certainly an interesting option to consider. The second major change in the APS is the One APS approach, which we've seen adopted in response to COVID, where up to 5,000 APS officers were mogged. They were not mogged, they were moved temporarily as part of the government's response to COVID. They were not mogged, instead they were moved under secondment arrangements under Section 26. So again, I think this demonstrates this theme that we've seen coming out of COVID, which is really testing the flexibility of existing structures and what can be done under them. Finally, before I hand over, I wanted to share my prediction for industrial relations in the next 12 months. Apart from this increased focus on flexibility and the reforms coming out of the IR roundtables, I think that we're going to see a real focus on independent contractors and labour hire arrangements. For those of you closely watching Workplace Express, you might have seen some recent cases which are really questioning that fundamental distinction between an independent contractor and an employee. I think we're going to see some High Court challenges coming out of that and some pretty major changes in that space. On that note, I'm now going to pass over to my colleague Ali to discuss the challenges that COVID has presented this year.
Terrific. Thanks so much, Belle. As Belle touched upon, it has been a tumultuous year and we have seen some unprecedented weather events and enormous changes at all levels due to COVID-19. Beyond the changes to our industrial landscape as a result of these events, including the introduction of JobKeeper, shutdowns and the enormous shift to working from home, for me there has been really three standout issues that reflect the events and challenges that have been faced. The first is the increased reliance on the Section 524 of the Fair Work Act. As COVID-19 began to kick off in early March and affect more and more businesses, we began to see an increased attention on this section, which allows employers to stand down employees without pay for reasons including where there was a stoppage of work for which the employer was not responsible, which meant that there was no useful work for employees to perform. The attention given to this section was interesting in part because before the events of this year, aside from a couple of cases, there was little guidance for employees or employers about when employees could legitimately be stood down under this section or what the entitlements of employees would be when they were stood down. Since then, we've seen a number of cases come through the courts, and we now have a greater understanding about how this section will be applied in practice. The first case is one that you may already be very familiar with, which is the case of CEPU and Qantas Airways Limited 2020. So this case raised the question of whether workers stood down under Section 524 were entitled to sick leave while they were stood down, I should say employees. Although employees could request to take annual leave and use this and other similar entitlements, while stood down, the status of sick leave was far less clear. Consequently, the CEPU brought an action against Qantas in the federal court, arguing that the stood down employees were entitled to sick leave in addition to other types of leave available to them. Justice Flick disagreed, finding that paid personal leave exists as a form of income protection. Justice Flick reasoned that if there is no work available to be performed, there is no income to be protected and therefore no entitlement to the income protection afforded by paid personal leave. So this case really did give us greater insight into the operation of Section 524 with respect to employee entitlements. It also raised the question about how courts might treat other types of leave in the future, particularly carers leave, which shares a lot of similarities under the Fair Work Act with personal sick leave. Further, we've also seen the introduction of the JobKeeper Enabling Directions, which my colleague Caro will touch on in a moment. However, this scheme is scheduled to be phased out in early next year. If this does occur, we are likely to see a renewed interest and a renewed scrutiny on this section and further cases coming through the courts. Cases have also shed some light on what will be a legitimate reason to stand down employees. We might not have time today, but in particular, I'd encourage you to all read up on the case of Michael Marson and Royal Princess Cruises 2020, which is set out in your booklet. This case gives some useful guidance about how courts will consider what will be a stoppage of work for which the employer is not responsible, and also whether or not an employee can be usefully employed in a given situation. Overall, however, it seems that an event like a significant business disruption or an enforceable government direction that requires businesses to close down and cease trading completely will likely be a valid reason to enact a stand-down decision under Section 524. By contrast, a mere deterioration of business conditions, where the businesses can keep trading, albeit less profitably, will not likely meet the requirements of Section 524. In any case, whatever the reason, you should always consult with your employees about any stand-down direction, particularly as required under any applicable awards or enterprise agreements. This brings me to my next theme, which is we have seen an increasing emergence of novel or challenging WHS risks that employers and workers are needing to contend with. For example, over the summer, we saw the threat of bushfire smoke lead a number of employers, such as Australia Post, to cease trading in Canberra, cease deliveries, I should say, because of the threat that smoke posed to their worker health and safety. These novel risks are also impacting other areas in unexpected ways. For example, it might be that they would justify a stand down under Section 524. Similarly, these risks can create serious contractual disputes when they cause delays, including leading to disputes about whether they qualify as force majeure events, which we'll touch on in a moment. These risks to health and safety have also really pushed the boundaries of what states can direct their citizens to do, which we've seen through the various public health orders and directions coming out in every jurisdiction, in particular, most recently, Victoria. This has in turn raised very interesting questions about what employers can direct their employees to do and what will be a legitimate and lawful and reasonable direction in these circumstances. The case of Guerin neatly ties into a lot of these themes. And so this case involved an employer, One Key Resources, who in early March this year directed their workforce to disclose their travel history over the previous 5 weeks, and whether or not this was to countries that the government at that time had declared as hotspots. An employee of the business refused to comply with this direction on the grounds that it would breach his privacy. One Key Resources continued to request that he fill in this survey, and he continued to refuse. One Key Resources subsequently dismissed him for misconduct in mid-March. For the Fair Work Commission, One Key Resources cited the close environment in which its workers worked, and that by not complying, the employee posed a WHS risk to fellow employees, workers and clients. It also noted that it had designed the survey to be as non-invasive as possible. The Fair Work Commission agreed, finding that the information that One Key Resources had requested was not sensitive personal health information under the Privacy Act, and that the overarching purpose of the direction was to ensure worker health and safety. The direction was found to be lawful and reasonable in the circumstances, and the dismissal of the employee for non-compliance with this direction was justified. This case highlights that we are increasingly in uncharted waters when it comes to managing extreme changes to our work and what will be lawful and reasonable in the circumstances. Directing employees in these unpredictable situations can be treacherous, and employers should tread very carefully, particularly where it would potentially involve the collection of sensitive personal health information as defined under the Privacy Act. Finally, the final theme I will touch upon before I hand over to my colleague Caro is disruption. What all of these crises have had in common was that they disrupted normal business operations and have created novel and challenging problems. They were all also to varying degrees unpredictable. These events highlight the importance of risk mitigation and planning to manage these challenges. It is important to assess the weak points in your organisation. What supplies do you rely on? What technology do you have? What is your exposure to various risks, be they cyber, environmental, physical? How do your workers do their work, and where do they do this from? How would your business cope if certain risks manifested and key assumptions or conditions in the market changed? Now is the time to review your policies and, if needed, develop new ones. Review or develop a disaster response plan, a business continuity plan, or a pandemic and infectious diseases plan, and make sure that these are fit for purpose. It should also be a time where you review your contracts and ensure that any force majeure clauses that you have are fit for purpose and that they operate in the way that you think they should and are adaptable to changing events and climates. That's all from me today. I'll now hand over to my colleague Caro, who will speak to you shortly. Thank you.
Thanks, Ali. I'd like to talk about some of the flexibility changes that we've seen in the wake of the COVID-19 pandemic, where we saw employers drastically change their businesses and entire workforces move to working remotely rather than working from work. One way that the government sought to address the impact of COVID-19 in the employment context was to amend the Fair Work Act to create the temporary JobKeeper scheme. To give a brief overview of the scheme, employers will be eligible if they have been significantly affected by the pandemic, which is judged by a percentage reduction in turnover. They can then access a wage subsidy of $1,500 a fortnight per employee during the JobKeeper period. In addition, employers can take measures under the scheme in relation to the performance of work at their business. They can do this in two ways. First, by issuing JobKeeper enabling directions to employees, and also by reaching agreement with employees in relation to their hours of work and the use of their leave entitlements. Initially, the JobKeeper period was going to end on the 27th of September. However, in July, the government announced that instead on this date, JobKeeper 2.0 would kick in and extend the scheme on a modified basis until March next year. Under JobKeeper 2.0, the fortnightly payment rates will reduce quarterly for eligible employees whose normal working hours are less than 20 hours per week. Businesses will need to continue to establish the reductions in turnover with reference to their actual turnover to continue to access the scheme. One part of the JobKeeper scheme that particularly interested our team was the jurisdiction of the Fair Work Commission to determine disputes under the new provisions of the Fair Work Act. The Commission under the scheme has jurisdiction to deal with disputes about the directions that are issued to and agreements reached with employees. In addition, certain employment decisions that are made under the auspices of the JobKeeper scheme can attract the protections contained in other parts of the Fair Work Act, like general protections. However, we haven't seen any examples of this being used at this stage. The Commission does not have jurisdiction to consider some common questions that crop up under the scheme, such as whether employees are eligible for the scheme and how employers are passing the payments on to employees. However, despite this, the Commission can make recommendations about these matters, which was what we saw happen in a recent case, which is up on the slide there, called Matthew Guerin and Horndale Pty Limited. To give a brief overview of the facts of that case, Mr. Guerin had been a casual employee in the bottle shop of the resort, which I'll call Horndale, since March 2019. He worked one shift per week on the weekends, which earned him about $300 a week. At the same time, he was studying at university during the week. Under the JobKeeper scheme, which Mr. Guerin was eligible for, he was receiving the $1,500 per fortnight, which was a pretty significant increase on his $600 odd a fortnight previously to JobKeeper. In May, after he'd been receiving the payments for some time, Mr. Guerin's boss phoned him and said words to the effect of JobKeeper's not free money, and asked him to commit to working extra hours at the resort. Due to Mr. Guerin's university commitments, he was not able to take on these extra hours. The following fortnight, Mr. Guerin noticed he was no longer receiving the JobKeeper payments. He made inquiries with the ATO and the Fair Work Ombudsman and made an application to the Fair Work Commission. Ultimately, though, because the dispute was about Mr. Guerin's eligibility for JobKeeper, the Commission did not have jurisdiction to consider the actual dispute. However, Commissioner Hunt felt that it was appropriate to make a recommendation about how Horndale should proceed in the circumstances. In the Commissioner's view, the evidence was clear that Horndale had decided that because Mr. Guerin was not willing to work the additional hours, he should be removed from JobKeeper and no longer receive the payment. In fact, as Commissioner Hunt said, there was no sound basis for Horndale to make this decision. The Commission noted that Mr. Guerin may be able to bring a general protections claim against Horndale, and in these circumstances, Commissioner Hunt recommended that Horndale continue to pay Mr. Guerin the relevant payments under the JobKeeper scheme until the end of the JobKeeper period. Now I'd like to quickly talk about workplace flexibility, because we think this might be a bit of a big issue once COVID kind of calms down a bit. And what happens if your employees have realised that they like working remotely and would like to continue to do so following COVID calming down? Well, employees who would like to continue to work flexibly will need to request flexible working arrangements, often called individual flexibility arrangements or IFAs, from their employer. Employees' rights to request IFAs comes from the National Employment Standards in Section 65 of the Fair Work Act. For businesses who are covered by enterprise agreements, the process of requesting and approving IFAs is usually covered in your agreement. However, something to think about as employees are starting to consider flexible work on an ongoing basis is that remember that the entitlement under the NES is to be able to request flexible working arrangements rather than have them granted. They are not automatic once a request is made. On that note, to take a deep dive into the year that was in the workers' entitlement space, I'll now hand over to my colleague, Nick.
Thanks very much, Caro. And I think it's a little bit ironic that we move from talking about workplace flexibility to workplace entitlements, and specifically two cases that will arguably have the effect of stifling flexible working arrangements moving forward. I'll have more to say on that in a second. But I wanted to just very quickly touch base on another issue that has been in the worker entitlement space in the last year, and that's been a continued focus on employee underpayment, with a number of high-profile cases arising after George Columbaris' fall from grace, and his matter largely got the dominoes falling. The ABC and both major supermarkets have been implicated in an underpayment issue and have agreed to pay back large amounts of money to those employees in the recent months. This can obviously only be seen as a good thing, but it is a timely reminder that large employees with sophisticated payroll systems are still susceptible to underpayment issues, be they inadvertent or otherwise. Only yesterday, we saw one of Australia's large universities also agree to pay back a large amount of underpaid wages. So I think it's something that we all need to keep an eye on moving forward, and remaining also vigilant to this issue and ensuring that you have in place good systems to avoid the risk of underpayments as much as possible. But what I think ranks as one of the most significant cases in the last 12 months relates to employee classification and, in turn, worker entitlements. And that's the case of Rosato and WorkPac before a full bench of the federal court. If the name WorkPac sounds familiar to some of you, we most certainly have spoken about it in Years in Reviews in years gone by. They were involved in another case a year or so ago, also relating to worker entitlements. That one was the WorkPac and Scheme case, also in the federal court. But in the Rosato matter, WorkPac employed Mr. Rosato for 4 years and supplied his labour to the Glencore Group under 6 consecutive contracts. Mr. Rosato claimed he was owed leave entitlements as a permanent employee, even though his contract said that he was a casual, and he eventually took WorkPac to court on that basis. WorkPac argued that Mr. Rosato was a casual employee because there was no firm advance commitment as to his hours of work. They also argued that the court should determine his casual status by virtue of his contract of employment only, and not the way he actually performed his job. The case turned on what constituted a firm advance commitment, essentially, and the full bench did decide in favour of Mr. Rosato, and in doing so, they took the view that the totality of the employment relationship needs to be the consideration, not just what the words in the contract are. And look, other relevant factors that they outlined for the benefit of considering this moving forward are the duration of the employment, whether the contract of employment describes a regular or intermittent nature of work, if the contract permits the employer discretion on whether to offer employment on a particular day, and conversely, whether the employee could decide whether to take on the work when offered it or not. And these indicia are quite common in the assessment of determining whether or not a person is a employee or an independent contractor after the Vabu case handed down by the High Court some years ago now. So they're really trying to bring that sort of indicia test into this as well. So obviously, as I said, Mr. Rosato was successful, and WorkPac, upon learning this, made a submission to the federal court, the full federal court, that was in circumstances where they were unsuccessful in determining that he was a casual, that they should be able to effectively offset the amount of money that the court determined Mr. Rosato was entitled to for leave, for example, on the basis that they were providing him with loading in lieu of the fact that he was a casual. And any entitlement should be offset against that amount. And look, I think in probably what is the most troubling aspect of this decision for me is the court said that this is not an appropriate way to deal with the issue. In essence, the employee has been treated as a casual, classed as a casual in the first instance, and being paid as such, then being deemed later on in a challenge to be an ongoing employee and entitled to leave entitlements that cannot be offset against the amount in lieu that you would not have received if you were classified as an ongoing employee from the outset, if that makes sense. It effectively creates, in my view, a double-dipping allowance that I think the government will be very keen to see removed. And look, I think it's particularly problematic at the moment where many employers are running on the bare minimum, and it leaves the real possibility that many of them may be left liable to back pay potentially a large sum to employees that they may have been treating as casuals in the past. In this day and age where the economy, jobs, and in particular small businesses are so vital, this decision may be seen as an unsatisfactory set of circumstances for the government. Look, the APS still, whilst they're not, at the moment in survival mode, they may also be susceptible to this decision, and they should reconsider the manner in which they engage many intermittent and irregular employees under the Public Service Act, under that particular provision, and whether their employment may be more suitably classified as ongoing if this was ever challenged. So what's next? Well, WorkPac have sought special leave to challenge this decision in the High Court, and the Attorney General, who is also the Industrial Relations Minister, has said that the government will intervene. I think anything short of a full successful appeal by WorkPac overturning the federal court's decision is likely to see legislative intervention, with the most talked about amendment being to the Fair Work Act to more clearly define a casual employee. It's possible that that may still come anyway, even with a WorkPac victory, because there is a little bit of confusion around that fact at the moment. The question, of course, will always be, as it seems to be regularly in significant reform, how will it fare if it gets through to the Senate? And look, perhaps those working groups that Belinda was talking about earlier can assist with a bit of a bipartisan solution that may be able to bring that through to a conclusion sooner rather than later. Personally, I think leave will be granted. I think this is going to be one of the most important cases of the next 12 months, especially, as I said, with employment being so precious at this time and businesses looking to tighten their belts as much as possible. And I suspect we'll have more to say on this one next year, when we hopefully meet face to face and can enjoy the canapes that Clayton Utes is so famous for in Canberra. I'll pass on to Lauren now, who'll talk about another important case on worker entitlements. Lauren.
Thanks very much, Nick. Yes, so today I'm going to take you through a case that is quite technical in nature, somewhat of a labyrinth insofar as interpreting legislation is concerned. It's the Mondelez matter, and this case relates to the accrual of personal leave under the Fair Work Act and the very complex arguments that have been put before the court about a very short word and its interpretation, and that is a day. If you haven't been following these proceedings too closely, that's all right. Sit tight, don't worry. I'm going to give you a wrap up of where we're at so far. So the facts are, Mondelez Australia, which is part of Mondelez International, a large multinational employer and home of delightful snacking brands such as Cadbury, Pascal and the Natural Confectionery Co., sought approval of an enterprise agreement which contained different entitlements to paid personal carers leave to its shift workers and non-shift worker employees at a Cadbury's plant in Claremont, Tasmania. It gave employees who worked 3 12-hour shifts a week with 96 hours of personal leave, contrasted with other employees who were entitled to only 80 hours of personal leave. In considering the agreement, the Fair Work Commission was concerned that 96 hours was actually not enough to meet the 10-day minimum requirement in the National Employment Standards, which required employees to be provided with at least 120 hours, which is 10 12-hour shifts. Mondelez then sought declarations from the Federal Court regarding the operation of the relevant clause in the agreement and the correct interpretation of 10 days contained in Section 96 of the Fair Work Act. The then Minister for Jobs and Industrial Relations also intervened in the application. So the matter was heard before the full federal court on the 21st of February last year. And before the full federal court, Mondelez contended that the reference to 10 days meant 10 notional or average days. And a notional day, according to them, was an employee's average weekly ordinary hours divided by 5, because there are 5 standard working days in a week. However, beyond the concept of notional days, Mondelez's argument was consistent with the minister's, and that is an employee's paid personal leave entitlement was their ordinary hours of work in a 2-week period. AMWU and the 2 Mondelez shift workers that were part of these proceedings argued that the entitlement to 10 days of paid personal leave was to 10 separate days and that a day was meant a 24-hour period. The majority of the full bench found that the word day is used in a specific context of an authorised absence from work for a reason set out in Section 97 of the Fair Work Act. And in that context, its natural and ordinary meaning is in fact what the AMWU say, which is a portion of a 24-hour period that would otherwise be allotted to working. And in this sense, a day, according to the full bench, could be described as a working day. But this would mean that taking the ordinary meaning of 10 days of paid personal carers leave in Section 96 is an absence from work for 10 such working days. So the full bench majority didn't accept Mondelez's argument that a day had the industrial meaning of a notional day, and it instead accepted the argument that had been put forward by the AMWU, despite arguments from Mondelez saying that an employee who works fewer or longer shifts effectively gets more paid personal leave based on this interpretation than an employee who works a standard 5-day week, even though they work the same hours in a week, and that this outcome would be inequitable. So these were the issues that were put forward before the High Court for consideration as part of the special leave application. Now, this one is hot off the press because the High Court only heard this matter on the 7th of July, just a few weeks ago, and the proceedings definitely kicked off with a bang. On opening the hearing, Chief Justice Kiefel said that in relation to each of the parties' estimated time for their oral arguments, he said, whilst I appreciate that the time estimates are always at the point of commencement of argument provisional, they do seem somewhat luxurious in the sense that we seem to be going to take a day and a half to argue about the word day. Clearly, she wasn't very happy with the parties in that regard. But at the High Court, counsel for Mondelez reiterated its notional day construction argument that it put forward in the full federal court proceeding. And it also said that there's a need for sections 96(1) and subsection 2, which refers to the manner in which leave accrues according to ordinary hours of work performed by an employee, to be harmonised. And that's best done by viewing the ordinary hours of work as a frame for determining the quantum of paid leave. Council again focused on the explanatory memorandum to the Fair Work Act, as it had done before the full federal court, and the way that it describes the entitlement to paid personal leave, and in particular that it refers to the quantum of paid leave not being affected by the employee's spread of overall hours. Counsel for the Minister emphasised these arguments made by Mondelez and further said when section 96(1) is read in conjunction with 96(2) of the Fair Work Act, that they must be read as reference to an entitlement that a particular number of hours would be accrued for every year of service, in part because the number of leave hours accrues progressively and the Act requires that the number of hours must be ascertainable by any employee at any given time, meaning they need to be able to see how many hours are left in their leave balance. Counsel for the AMWU submitted that the decision of the majority of the full federal court was correct, of course, and that is a day of leave refers to a portion of a 24-hour period that would otherwise be allotted to work, which is a working day, and that an employee accrues an entitlement to be absent from work for personal or caring reasons, such as 10 such working days per year of service. So in light of all of these technical arguments about what in fact a day means under these provisions in the Fair Work Act, High Court has naturally reserved its decision, and it's likely that we won't hear an outcome from them for a few months. However, the Fair Work Ombudsman and the Public Service Commission in the meantime have sent out communications to agencies indicating that Mondelez, according to the full federal court interpretation, is law, and as a result, employers should be following it. This is no doubt creating many headaches from a systems perspective, given the need to essentially overhaul the entire leave calculation process from start to finish, which will likely be a very costly exercise. Based on the comments of the High Court and its engagement with submissions from Mondelez and the Minister, being that their interpretation of the word day was better aligned with the context of the Fair Work Act, I do think we will see this decision overturned, but indeed time will tell. And with that, I'm going to hand over to my colleague, Charisse.
Hi, Charisse here. Today I'm going to speak with you about workers' compensation and work health and safety development. There's so much to cover, so I have picked a few of the most topical issues to discuss with you. The first thing to note is that industrial manslaughter laws continue to expand across Australia despite the long-standing debate on the effectiveness of such laws. The ACT, Queensland, the Northern Territory and Victoria now have some form of industrial manslaughter offence, with Western Australia's in the works but not yet approved by Parliament. That leaves New South Wales, Tasmania and South Australia as the states without specific industrial manslaughter offences. The federal government has previously stated it does not consider industrial manslaughter offences are effective and are any more effective than the existing laws, and it does not intend to introduce any. On that note, the first industrial manslaughter prosecution was completed this year, with the decision handed down in June 2020. This was the case of the Crown and Brisbane Auto Recycling and others. This was a Queensland case where an employee was crushed by a forklift, which was being reversed by another worker, and the employee later died from his injuries. The Queensland District Court was scathing in its review of the employer and found that there were no safety systems in place. The forklift driver did not have the required licence to drive the forklift. There was inadequate supervision of the forklifts, And, most importantly, the directors had consciously disregarded safety risks that they were aware of. The company was found guilty of industrial manslaughter, while each of the directors pleaded guilty to a Category 1 reckless conduct offence. The court fined the company $3 million and imposed a 10-month imprisonment on both of the directors, wholly suspended for 20 months. This case only provides limited guidance, given that most businesses will have greater levels of risk assessment and will address known safety risks. However, now that we have one case, it is likely that we will have more. Another important case in this space is the case of May and the Commonwealth of Australia and Helicopter Resources. In that case, the Commonwealth was found guilty of breaches under the Commonwealth Work Health and Safety Act, following the death of helicopter pilot David Wood. So Mr. Wood was an employee of Helicopter Resources who was engaged by the Australian Antarctic Division to transport aviation fuel to remote sites in Antarctica on the West Ice Shelf. During one of these trips, Mr. Wood stepped on a snow bridge which collapsed, causing him to fall into a crevice. His co-worker could not rescue him alone and had to leave to get help. The colleague and the help did not arrive for 4 hours, with Mr. Wood being stuck in the crevice that entire time. Mr. Wood later died from hypothermia. The department tried to argue that the primary responsibility lay with Helicopter Resources. However, the court found that as the Commonwealth hosted the operations and were the subject matter experts in relation to operations in Antarctica, they were therefore best placed to manage the risks around the hidden crevice. So moving on to workers' compensation, certain workers in New South Wales now have greater protections if they contract COVID-19. Where workers in prescribed employment contract COVID-19, there is a presumption that it was contracted in the course of employment. Prescribed employment includes a range of industries, including healthcare, retail, education, police, courts, food service, construction, and cleaning. By determining when such illness is obtained in the course of employment, workers become entitled to the workers' compensation system. For example, if the worker suffers a permanent impairment as a result, they are entitled to a lump sum payment, and there are also death benefits. WA is looking to introduce a similar bill which provides an assumption that any healthcare workers who contract COVID-19 did so in the course of employment. It is possible that other jurisdictions will also look at introducing similar laws. So finally today I wanted to talk to you about a workers' compensation case, Workers' Compensation Nominal Insurer and Hill. In this case, a woman was tragically murdered by her partner in their home. How this became a workers' compensation matter is because Miss Carroll worked from home and Mr. Hill was also her boss and her co-worker in their family business. The New South Wales Court of Appeal held there was a sufficient connection between the work and harm caused and upheld the decision to pay workers' compensation benefits to Miss Carroll's 2 children. In particular, the court placed weight on the fact that Mr. Hill had delusions that Miss Carroll was trying to steal his clients, which may have prompted the attack and the murder, as well as the fact that she was likely to have been working at the time, likely to have been murdered during work hours. This is a unique case given the working relationship between the parties. However, employers need to be aware of the potential dangers of domestic violence while allowing employers to work from home or requiring them to work from home. These dangers are real and the risk should be considered when requiring them to work from home. Thank you all very much for listening. I will now hand over to Georgia.
Thank you, Charisse. It has been another big year in the space. By the end of the first 3 quarters of financial year 2020, the Fair Work Commission had 1,000 more applications than the same period the year before. In May, the Fair Work Commission reported that unfair dismissal claims had risen by 70% during the COVID-19 crisis. This increase is not surprising, with ABS data showing that almost 1 million Australians have lost their jobs as a result of the pandemic. In the redundancy space, the COVID-19 pandemic has resulted in huge numbers of redundancies across a range of industries. This number is likely to rise if and when JobKeeper wraps up. Despite the dire financial situation of many employers,
the Fair Work Commission has so far been reluctant to reduce employers' obligations to pay workers their full redundancy entitlements without compelling evidence. We have extracted some of the most important cases across unfair dismissal, redundancy, and general protections in our booklet. I will be highlighting some of the most interesting decisions that have been handed down over the last 12 months. In Westlake and Illawarra Coal Holdings, the Fair Work Commission found that a long-serving supervisor had lost his employer's trust by deliberately manipulating his overtime payments. Mr. Westlake was summarily dismissed from the Dendrobium coking coal mine after his employer discovered that his overtime claims did not match his attendance records. Mr. Westlake quickly admitted to the conduct, but explained that he was just balancing his hours. His employer's additional hour policy provided that overtime did not accrue for the first 4 hours of a shift and was capped at 10 hours per week. Mr. Westlake normally worked 4 10-hour weekday shifts and a 13-hour weekend shift as an under-manager, the most senior staff member working underground. Mr. Westlake would claim for the 10-hour shift on the weekend and added the remaining 3 hours to the end of a shorter shift during the week. Although Mr. Westlake claimed that his conduct reflected custom and practice, the mine's general manager successfully told the Commission that it had dismissed Mr. Westlake due to the deliberate breaches of policy rather than the amount of money that he had incorrectly claimed. The Commission determined that Mr. Westlake's conduct justified his summary dismissal because an employer must be able to trust senior managers to act in strict compliance with all policies and procedures. In Joseph and Parnell Corporate Services, an employer was successful in recouping significant losses sustained due to an employee's serious misconduct. Mr. Joseph was dismissed from his role as the chief executive of Parnell, a veterinary pharmaceutical company, after a series of bad decisions. Unfortunately for Mr. Joseph, his bad decisions continued after the dismissal and ultimately cost him almost $1 million in damages. The federal court found that Parnell had 3 valid reasons for terminating Mr. Joseph's employment. Firstly, Mr. Joseph had disclosed commercially sensitive information in a notice to shareholders. The second reason was an incident that occurred in December 2015 when Parnell's global marketing executive brought her aging dog to the company's US offices to take part in an arthritis drug trial. When she asked whether the injection hurt the dog, Mr. Joseph jabbed the used needle through her jeans and into her leg. The federal court did not accept Mr. Joseph's version of events, that he had only pricked her leg after first gaining her consent and changing the needle. Parnell settled 2 cases brought by this marketing executive against the company and Mr. Joseph for assault and battery and gender discrimination. The third valid reason occurred at a company awards dinner in Hawaii when Mr. Joseph likened certain employees to dogs and made a fairly off-colour remark about certain employees eating dog biscuits and engaging in sexual activity. Mr. Joseph was unsurprisingly dismissed following these incidents. When Mr. Joseph challenged the dismissal, Parnell cross-claimed against him, and ultimately Parnell recovered more than $1 million for costs incurred by the company in defending various claims brought by former employees regarding Mr. Joseph's conduct. Finally, in BP Refinery and Tracy, a full court of the federal court upheld a Fair Work Commission decision ordering the reinstatement of Mr. Tracy, a BP oil refinery worker who was dismissed after sharing a parody video. Mr. Tracy was dismissed in January 2019 after he posted a video to a closed employee Facebook group in which he substituted dialogue from a protracted enterprise bargaining between BP and its employees to a scene from Downfall, a German language film about Hitler's final days. Mr. Tracy was dismissed on the basis that he had distributed material which is highly offensive and inappropriate. At first instance, the Deputy President found that Mr. Tracy had likened his bosses to Nazis and contravened BP policies. The full bench of the Fair Work Commission had a contrary view, finding that the video was satirical and that no reasonable person would consider that Mr. Tracy was comparing BP executives to Nazis. Rather, the video compared the protracted position that BP had reached in bargaining to the situation faced by the Nazi Party in April 1945. The federal court agreed, finding that it was outside the boundaries of legal reasonableness to conclude that Mr. Tracy's video had compared BP executives to Nazis. Following this decision, BP announced that it was considering its options, so watch this space. This decision should serve as a reminder to employers to ensure that its policies apply to employee conduct on social media, particularly in closed employee groups. Thank you. I would now like to hand over to Jennifer to conclude our presentation.
Thank you, Georgia. Well, that brings us to the end of our year in review presentations today. We've covered a lot of ground and an awful lot of information, and I thank those of you who've stayed for the whole presentation and taken in all the dense material we've covered. A lot of the key trends and challenges that have emerged in this area over the last year are related to a number of the personal and environmental challenges people have faced. We thank you for your time today and for trusting us with your workplace relations, employment and safety matters throughout financial year 2020, and we look forward to working with you again in financial year 2021. Thank you very much, stay safe, and we hope to see you soon.